Hello BADM 107 students. In this video we are going to get into the meat of the course, starting with a review obviously of Chapter 1, the Canadian Legal System. And what I do is, as I mentioned, I lecture from slides which you can bring up on your screen from the lecture guide posted to eLearn. On the little side of the screen, if you can work it that way, there is a number for the various slides. I've got it on my screen here. So as I'm dealing with certain items, I will try every once in a while to remember to say what slide number that is, just to help you with reference. So you can actually bring up the lecture guide, listen to my voice, and then you don't have to look at my bobbing head, or you can decide that I'm just so dashingly handsome that you want to watch me do this lecture. Whatever works for you. Okay, so now we're starting off, and the first thing I'm going to do is something that's on the slides, and I think I mentioned it in my opening lecture, is that these lecture guides are not intended to be notes for the course, because you can only put a certain amount of material on a slide before it gets too crammed. Obviously, you have to flesh that out by taking notes. Okay, that's where the textbook comes in handy, because as I'm lecturing, you can always go back and listen again and go back and listen again. But if something isn't clear, then you can go to the textbook, use the index at the back, find the material, and fill in blanks in your notes. All right, so we start off by saying it's not notes. You're expected to take notes. The second thing is a warning. Okay, typical lawyer. This is something actually very important for professors of law at UBC and Simon Fraser and places like that, and business instructors that teach law. Because we are lawyers, the tendency is to think that perhaps material that we're saying is good legal advice for something that is going on in your life. We have to be cautious here, because it's not that. To get really good legal advice, you have to actually tell a lawyer your specific problem and get that lawyer to then do some investigating, and then he or she will give you the advice necessary. So nothing in the lectures, nothing in the textbook, nothing in the materials is to be considered legal advice. The next thing is we get into this concept of risk management. Years ago, I was teaching business law, and I was asked to teach in the tourism department, and I said, sure, what course? And they said, well, it's a business law course. And it turned out that the course was really BADM 107. It was just called tourism something or other. But they called it risk management. And that twigged something in the back of my mind, that most lawyers now, well, I shouldn't say most, but a lot of lawyers now are taking the position that what they do is risk management rather than provide legal advice. So you can come into my office and you can say, oh man, I screwed up this, and and I'm being sued, and then I get involved and I solve your lawsuit, or we go to court and we fight it out or whatever. That's giving the legal advice when the problem has already occurred. Risk management is the approach by some lawyers that it's better to try to reduce the possibility of getting into a legal problem or being sued, rather than wait until the problem happens. Okay, so it's how to avoid the pits rather than giving legal advice after someone went in the pitfall. All right, so risk management involves four aspects: elimination of risk, reducing or managing risk, shifting risk, and retaining the risk. And this is discussed in the textbook in a couple of pages just following the pages marked XII. Okay, Roman numeral 12. So this is on like Roman numeral 13, but I forgot to put in the page numbers. No big deal. But anyway, the whole concept is you look at a business operation and you look to see what, and lawyers don't have to be the ones doing this. The business person can do it as well. You look to see how you can eliminate risk. You do a business plan, you find out you're not going to make enough money, so you don't do the business. You eliminate the risk. Or you have 4 products, and one of those products, the the profitability is extremely low. Well, in that situation, what you want to do is you want to eliminate the risk of losing money on that particular product, spend your time concentrating on the other 4 products, and then consequently you've eliminated risk. In adventure tourism businesses, you can see this happens all the time. Whitewater rafting, early in the season, when after the rains, the rivers are running extremely high and fast, but the rocks are down low, and so the risk is that as you're going down, the guide will not see the rocks in time to stop an accident from occurring. So the really good guides know the river, and they know, oh, there's this huge rock there. What we're going to do is we're going to eliminate the risk of a problem by avoiding that part of the stream. So there's a number of ways that you can eliminate risk. Reducing and managing risk. The easiest explanation here is in HR management. And again, I'll use a river rafting example because it's perfect. There was one river rafting company in BC that needed a guide. Fellow turns up from Australia. He's got a tremendous, outgoing, fantastic personality. Oh, Glenn, mate, how's it going, eh? And they go, are you a river rafting guide? Oh, yeah, mate, I've been guiding for years, eh? He said, you got your certificate? Oh, man, yes, I've got a certificate. What about first aid? Oh, yeah, I got my first aid certificate. No problem. They say, okay, well, can we see them and we'll hire you? And, oh, yeah, mate, but I'm in Australia. I'll have to get them sent over, eh? And everything gets delayed and everything gets delayed. They need this guy. They're doing, familiarity tours and everything like this. And finally, they're operating. And the owner of the company came and said, look, you have to give me your certificate for guiding and your first aid certificate. He said, oh, I don't got those, mate. And he said, what? He said, oh, no. He says, but now you know me, eh? You know I'm good. You know I can handle it, so no problem, eh? And the owner of the company says, yes, there's a big problem, because if there's an accident and you don't have your certificate and you don't have your first aid, it's not only you as the guide that's in trouble, but it's me as the owner of the business, because I did not do my due diligence. I did not hire correctly. Okay, so you can manage risk in that way. Okay, so we're talking adventure tourism businesses. No, we're talking every type of business. Before I retired, I had a really good client. Now he's a really good friend. And he ran a Sylvan Learning Center. And they hire instructors. If you don't know the Sylvan Learning Center, it's an after-school tutoring system developed in the United States where students come in and they do math and they do English and everything to upgrade their skills and do better at school. Well, they have to be careful who they hire, right? Because these are young children and young adults. Well, no, not young adults, because adults is 19 and up. So young children and sort of older children. But you have to hire somebody that is not a pedophile, to the best of your knowledge, right? So one of the ways you do that is you say, okay, I'm going to hire you, but I want to do a criminal record check. Well, he has a number of officers, and the manager wants to hire one of these people at one of those offices. And personable guy comes in, and she says, we really want to hire you, but you have to do this criminal record check. Would you sign off and allow us to do it? Oh, yeah, sure, no problem. He signs off, right? And she's very busy, so she doesn't get around to doing it. Pretty soon, he's teaching students. And she looks at the corner of her desk. Oh, there's that record check. Criminal record check. I better do that. She does it, and she finds out he has a conviction as a pedophile. Suddenly, the business is in a really awkward position in a couple of respects. Number one is they have to let this person go. And you can't do that because he did lie during the interview and said he didn't have a criminal record. But you have to get rid of him, and then the question becomes, do you fire him for misconduct, or do you, throw some money at him to get him to go away? And then there's the problem that you've been operating with a pedophile. Okay, so it doesn't do your business a lot of good. So attending to HR management is one of the ways that most businesses can reduce or manage risk. Profit or loss statements on a monthly basis keeps track of how things are going. Oh my God, the profit's been going down for 8 months. We are just about out of money. We are in trouble. Better to know that ahead of time, because you might be able to manage the risk of going out of business. Okay, then the other thing is shifting risk, and the two obvious examples are that you incorporate a corporation because the corporation is a separate legal entity, so it enters into contracts with other businesses. If that business wants to sue, they have to sue the corporation. They cannot sue the shareholders, directors, or officers of that corporation, as long as those people have done their due diligence, okay? So that's one way you can reduce the risk. Shift the risk. The other easiest way to shift the risk is get insurance. Okay. Now the thing to remember about insurance is that you can get a gazillion billion dollars worth of insurance, and it will not stop an accident from happening. By the very nature, an accident is something that you don't plan to do. Okay, it just somebody's careless and it happens. But what the insurance will do is will shift the responsibility for paying for that accident from the business itself to an insurance company. Okay, so that's what we mean about managing, eliminating, shifting the risk. What about retaining the risk? Well, one of the problems with ski hills, for example, is that they all want the skiers that come up to use the services and facilities to sign waivers of liability or be bound by that little verbiage on the back of a ticket that you buy. Children are not bound by those, okay? If they sign a waiver of liability and they're under the age of 19, this is not a contract for a necessary of life. Therefore, the hill has to honor the ticket, and yet on the other side of the coin, the ticket doesn't protect the hill against the youngster from suing if he's injured. Oh, well, you just get the parents to sign, right? Well, in the province of British Columbia, the Infants Act says that a parent cannot waive the rights of a minor. So you sign a waiver, yeah, go ahead, let my kid ski, and then the kid's injured, the kid can sue, and they go, hey, but wait, you as the parent sign the form, and the Infants Act says, yeah, but I cannot waive the rights of my minor children. So what do the ski hills do? If they said, oh, well, let's just make sure that nobody under the age of 19 skis, they go broke in an instant because there's a huge number of customers and participants that are under the age of 19. So they accept the risk, all right? And then they go back to shifting the risk. They get insurance. All right, so that's the whole thrust of the course will be risk management. And then the slide number 6 is talking about some terms that we have to know: substantive law, procedure law, public law, and private law. Now, here's a heads up for my exam. Part A is 15 terms and 18 definitions, and what you have to do is match the best term to the definition. And it's not like a multiple choice question, which I hate, because the only way they can really make those work is give you, sort of 5 options, and 2 of them are so closely similar that you're going, semicolons, ands, buts, which one's right? That's silly. What I want you to do is learn concepts, okay? So take false imprisonment, for example. The actual definition is the intentional and unlawful justification of a person's the intentional and unlawful confining of a person against their will, either by actively causing their confinement or from preventing them from leaving the place in which he is. Well, the problem with that is it's so convoluted. I mean, it's correct, but it's so convoluted that it's hard to remember. So you break it down into 3 elements: intentional, unlawful, confinement. All right. So I give you the formal definitions, and then you just have to say, okay, to understand that, what does it mean in English? And then you can actually go through part A, and if you had enough time, you could probably get a pretty good mark just by figuring them out. For example, I'm just grabbing the textbook because I do use the textbook, and you should too. Substantive law on page 4 is defined as the law that defines the rights and duties of people and organizational bodies in a society. But then I put it in English, or in other words, the laws that you have to follow. So you think, oh, criminal law, you cannot kill someone, you cannot rob someone. Yeah, that's a perfect example, but that's not the only example, okay? You cannot injure someone through careless disregard, which is, either relates to injuring a trespasser or negligence. That's not criminal law. That's tort law, okay? Or you cannot breach contracts. That's not criminal law. You don't get arrested and put in jail for breaching a contract. You have to pay damages for it. But the law says you cannot breach contracts, okay? So it's the law you have to follow. Procedural law deals with legal matters between, the body of rules by which one enforces his or her substantive legal rights. So in other words, just the rules, let's put it this way. How do I sue you? We have a contract and you breach it. You're sued. No, that isn't how you do it. You have to go to court. You have to file a notice of claim or a notice of civil claim. You have to pay a fee. You have to serve it on the other party. They have to file a defense. Then there's all sorts of steps before you actually get down to the trial. Well, this is the procedural law, the laws by which you enforce your substantive rights. Okay? The next term is public law. Deals with legal matters between one government and another, and matters between a government on one side and individuals or organizational bodies on the other. In other words, Regina versus Dudley and Stevens. Regina, is that a city in Saskatchewan? Well, yeah, it is, but it also means the Queen. So the Queen in Right of Canada versus Dudley and Stevens. Right away, you know that's going to be a criminal law matter or a what else could it be? It could be a human rights matter or whatever, okay? So it involves punishment. Then there's private law. The parties go to court to work out their problems themselves. It concerns matters between things like civil property rights and ownership of property, breach of contract, things like that. So the first one is Regina versus Dudley and Stevens. The second one is Holden versus Graham. Holden versus Graham, well, the government isn't involved, so it's private law. So it's matters between private individuals or individuals and private corporations. Okay, not a perfect division. For example, it may be Holden versus the government of Canada. Well, that could be public law because I could be saying that my rights pursuant to the Constitution Act have been infringed, or it could be me suing because I sold pencils to the government and have not been paid. Okay, so you can't tell for certain that the style of cause, which is Holden versus Graham or Regina versus Dudley and Stevens, is either public law or private law, but it's a good starting point, and those concepts come up all the time. Okay, the next element is the three legal systems of the world, and we're gonna do this in about 30 seconds because the last portion of the course deals with international trade law, and we'll get into those legal systems in a big way then. However, there are three. There is the civil law system, which is the oldest system. Okay, it involves countries in continental Europe, South America, Mexico, Vietnam, Japan, and to a certain extent China, where you have a code which all the laws are put into this code, and the courts look at the code only to make the decision. No reference to precedent like the common law system. So you don't come into court and say, well, in the case of Holden versus Graham, which is helpful here because the judge will say, what's that got to do with anything? Okay, it's an inquisitorial system where the judge is actively involved in the trial, and if there's no article in the code which deals with a specific instance, then the courts look for the closest section, and then they extrapolate from that. Okay, that's the civil law system. As I mentioned, European countries, with the exception of the United Kingdom, and South America, Mexico, Latin America, some countries in Africa, but Africa now has a lot of tribal law. Okay, we don't get into that, so it's not one of the three that we talk about. Israel, for example, is another situation that's different. That's Judean law, and again, we don't get into that. We just look at the three main systems. So that's the civil law system. More area of the world is covered by civil law. Then there's Islamic law or Muslim law. It's the Sharia, it's the Quran, the teachings of the Prophet Muhammad, the legal writings of Islamic scholars, and something that they call the legal consensus that's basically their procedural law. It covers more people in the world. Okay, the only country that follows Islamic law to the letter is Saudi Arabia, which is odd when you think about it. The United States' closest ally in the Middle East is the one country that follows Islamic law to the letter. Which brings to question, what's everybody fighting about? Well, they're not fighting about religion. They're fighting about oil. But it's really hard to get people to give up their lives by strapping a bomb to themselves and running into a crowded airport for the price of a barrel of oil. But you can certainly do it if you say they're going after our religion. Anyway, that's the more people in the world are covered by Islamic law. The other jurisdictions like Iran and Iraq and Afghanistan have Islamic law, but they were colonies of France, so they have a mixture, mostly Islamic law, but some civil law. Egypt is schizophrenic. The French were in there, the British went in and kicked the French out, and then eventually the Egyptian kicked the British out. So they've got elements of all three systems involved in theirs. The third system is common law. It's judge-made law, stare decisis, application of precedent, and it developed over a long period of time in the United Kingdom, and then spread throughout the world with the British Empire. So we have Canada, mostly common law, the United States, mostly common law, Australia, New Zealand, India was common law, and now they follow mostly those rules, although their legal system is changing slowly. So it's the application of precedent. It doesn't mean that we don't have codified laws. We do have statutes. The difference is in civil law situations where you have a civil code, the code speaks for itself, whereas a statute in a common law jurisdiction has to be judicially interpreted before it becomes final and binding law, and that judicial interpretation comes by way of judge-made law. Okay, that's all we're going to say about those. The next slide, however, is the definition of law and the purposes of law, and then something that I am really big on, which means it may find its way into the midterm exam, and that is the rule of law. The rule of law is under attack in the United States, where we have a president who thinks, and I'm getting up my soapbox a little bit here, thinks that he is king and he is above the law, and so he's gutting the Attorney General's office, he's gutting the Secretary of State's office, he's trying to control the military and put himself in a position where he has complete control of everything, okay? Because the rule of law is under attack in the United States, I spend a little bit more time than usual on it, and I had the good fortune of, when I started watching what President Trump was doing, I had the good fortune to go to Europe and the United Kingdom in particular, and I wanted to go and see the Magna Carta. Because the Magna Carta is the document from which our rule of law and our civil liberties sprung. Up until then, the king, like Trump wants to be, was anointed by God, God's actor on earth, and could do anything he or she wanted. Okay, king or queen. The Magna Carta, I think it was like 83 barons in England were overtaxed, and the king wanted to raise an army to, go off and have a good war, and so they rebelled against him, and they said, "We will pay the taxes, and we will, provide soldiers for your army if you sign the Magna Carta." And the king was broke; he had to do this, so he signed the Magna Carta in 1215, and I have on one of my slides, let me just look at it here, slide 12, and I'm going to have to read it. So, no free man shall be taken or imprisoned or desinized, which means have his goods stolen from him, or exiled in any way destroyed, except by lawful judgment of his peers, or by the law of the land. Okay, so the king could no longer do it. There was going to be judges that made it. And that was in Article 39. Article 40 says, "To no one will we sell, to no one will we refuse or delay right or justice." So in other words, you can't slip a couple of bucks to the judge and, get what you want, or give some money to the king and get what you want. And that was the start of our legal freedoms. And then from that became, lawful judgment of his peers meant you had to have due process of law before you could be imprisoned or that sort of thing. So our legal principles sprang from the Magna Carta, and then slowly we got our civil rights as well. Okay, so I went to Europe and went to the United Kingdom, and my kids wanted to see the Big Ben and the Tower of London and all sorts of things, and they wanted to see the Stonehenge. I wanted to see all that too, but I made a pilgrimage. I literally made a pilgrimage to the Salisbury Cathedral, where I saw the Magna Carta. And I am not embarrassed to say that it was extremely emotional for me. And my kids were surprised when I got a tear in my eye looking at it, because I realized more than the average person, because of my legal training, just how important this document was to our legal and social history. And I came back, and I guess I'm going to get up my soapbox a little bit here, because, that's the United States. Oh, it's happening down there, but it could never happen here. Well, just before the last federal election, the Conservative Party were in opposition, and they had a leadership convention. And one person, who I shall not name, that was running for the leadership of the Conservative Party, began spouting the same rhetoric as the President of the United States, thinking that perhaps here it would strike the same kind of nerve that allowed people to make the stupid decision and elect Trump. I got actively involved in politics, which I hadn't been for a long, long, long time, just because I wanted to ensure that that person did not gain power, to the best of my ability. Okay, as it turned out, he, or she, I can't remember, was it he or she? Anyway, dropped out of the race. Okay, so problem solved for a while, but I think we have to be very careful and cognizant that our civil liberties, which we just take for granted, are not guaranteed. Okay, our right against the operation of law is not guaranteed. These things require us pay attention to government. It requires the appointment of unbiased judges to our court systems, and all sorts of things. And we can do something about that. So take that with you from the course. That's a freebie. Now I'm getting down off my soapbox. Incidentally, the dean says that I can do that as long as I tell you when I'm on the soapbox. Okay, so on slide 8, we have the rule of law. Okay, we have the rule of law. The civil law jurisdictions developed the rule of law differently than we did, but they have it as well. And it's stated really nicely on that slide. And once again, I'm going to have to move my sheet here. The sheet, by the way, I cover the screen so that I remember to look at the camera. Otherwise, I'll be looking down the whole time like this. Okay, the rule of law, the legal principle that the law should... It's just off the screen here, so let me... I can't get it. There we go. Should govern a nation as opposed to being governed by decisions of an individual government official. It primarily refers to the influence and authority of law within society, particularly as a constraint upon the behavior, including behavior of government officials. So you can see why Trump wants to get rid of it. Oh my God, it's a constraint on me. I should be king. I should be able to make these decisions. So we have to be careful about that. I've got a picture of a drawing of King John signing the Magna Carta, and a picture of his seals, which I'll come back to later. There's only 3 of the contracts. That's all it was, really. It was a contract that are left. Every baron got one, and the king got one. But they've been destroyed or lost over time. However, and I should just mention a little bit more about the history. On slide 13, it shows a picture of the... it's a mock-up of the Magna Carta with the king's seal attached to it by a ribbon. The seals were lead at that point. Eventually, we'll get into how the seals developed. The slide 14 is a papal bull. No, not bull as in bull Tweedy. The papal bull is where we got bulletin from. King John, after he signed the Magna Carta, didn't like the fact that he was constrained once he got his money. So he had the Pope cancel the Magna Carta by way of the papal bull. Why have we still got it? Why is it so important then if the Pope canceled it? Well, there were things that King John didn't like about it, but it wasn't the freedoms thing. It was other things. And so it was redrafted and signed by, I think, his nephew, the next king or whatever. And it was canceled and re-signed again. But during all of that, what survived was the Articles of the Barons that relate to our civil liberties. All right, we talked about public and private law a little bit. On slide 16, I show the various types of legal matters that fall within the public law and private law categories. And on the left-hand side of the screen is things like criminal law, constitutional law, taxation, and then there's one called marketing and advertising, and you think, well, isn't that kind of like private law matters, marketing and advertising? No, it's because under the Competition Act, or under the federally, or under the BC Business and Consumer Protection, Business Practices and Consumer Protection Act, if there's a complaint about advertising or marketing, you make it to the government, and then the government investigates. So it's the government against the business, rather than a private person going after the business. Taxation, obviously. International law is on both sides, because international law can relate to conventions or treaties like the United States-Mexican-Canada Agreement, which replaced NAFTA. And administrative law, it's the Human Rights Act, it's the other government agencies going after people, like the Competition Bureau for marketing and advertising. Okay, so your first step isn't going to court; it's going towards in front of an administrative tribunal. On the other side of the equation, there's torts, there's contracts, estates, ownership of property, and all those. And then there's intellectual property, and you think, whoa, we file patents, copyrights, trademarks, and industrial designs with the federal government, so wouldn't that be public law? No, the federal government provides us registries where we can file our protection. But if someone infringes our trademark or infringes our patent, the government doesn't do anything about it. Okay, the business has to go after the person that's infringing their intellectual property. So it's on the private law side. International law is on the private law side. Why is it on both sides? Well, obviously, conventions and treaties have to be on the public law side, but on the private law side, if I have a contract with somebody in Mexico and they breach the contract, the government doesn't do anything about it, I have to sue them either here or go down there and sue them. And then we get into a thing called conflicts of law, which we'll talk about at the end of the course. Okay, so that's enough said about that. Stare decisis, to stand by previous decisions. It is the concept of precedent. And I am going to do a separate little video when I talk about precedent, because really it involves, let's see, is it actually there? No, I talk about it later on in the course. It involves how courts handle it. Like, for example, when I was practicing law, there was a radio station that got sued because they had a contest promotion. Somebody thought they should have won it. And so they sued, saying that we should have gotten the $10,000 prize. Okay, and I had to defend the radio station. And I found two cases which helped my client's cause. It didn't help my client's cause. It gave the answer. Okay, so this is one of those rare circumstances where we had to go through the trial anyway, but that the answer was set out in one or two cases. So I presented the cases to the judge, and the judge, although was not very particularly fond of my client or my client's position, felt bound by precedent. Stare decisis dictated that there was a court higher jurisdiction than his, which dictated the result. That's very rare. Okay, usually it's not quite that simple that there's one case that gives the answer, otherwise you would not be in court. There's generally a number of legal issues in a trial, and there's numerous cases that have to be dealt with. Okay, and so the courts can do a number of things. If it's a BC case and there's a BC precedent, they apply that. Okay, if there's a BC case but there's no precedent in BC that's applicable, they can find one from another jurisdiction and they can follow that. They cannot apply the law of another jurisdiction, but they can follow common law jurisdiction. Okay, or they can look at all the cases and say, well, they've been very helpful but not determinative. They don't tell me what my answer should be, so I have considered them and make my own decision. Or there might be a case that has been wrongfully decided in the past for any number of reasons, okay? And the judge, rather than saying, oh, I must follow it, they can actually overrule that case. Very rarely this happens, okay? So there's sort of four basic things that they can do. And I'm going to get into an explanation of that more thoroughly in this other video because I want to use it for a couple of my classes. So you have this concept of precedents. And jurisprudence is a term which just means cases that have taken place, okay? For example, a statute is not considered to be finalized until it has been judicially interpreted by jurisprudence. Okay, so I'm going to stop there for a minute and get myself another cup of coffee. All right, I'm back. Now, the stare decisis and consideration and overruling and stuff is all on page 9 of the textbook. So if you need some more information, that's where it's found. The next section is sources of law in Canada. We used to use this other textbook which talked about 4 sources of law and didn't talk about some of the others, and so I just fleshed it out and made it 8. And it's blank on the lecture guide because in a classroom we would go through that and we would fill it out on the whiteboard. So this is on page 20 of the textbook, but I'm going to go through those. This, however, is a good place to stop for a second and talk about the midterm exam. Boom, now yours, pure cup, right? I have Part A, which I've already talked about, 15 terms, 2 marks per term. It gives you a chance to, right off the bat in an open exam, to get 30 out of 30. The danger here is that you are going to spend so much time making sure that you get your 30 marks that you will not have enough time to adequately do the rest of the exam. So you really have to know the material, because if you went through and you found 27 or 28 of those terms right off the bat, and there's only 3 that you have to look up, you will not spend too much time on it. If you have to look up, 12 of the 30, you are going to run out of time. So in that material that I handed out, that file that says how to pass this course, I think it's really important to use Quizlet if you wanted to do it on your cell phone, or use index cards if you're old school. And it's not enough to do the index cards and say a term on one side, like assault with apprehension of intentional unlawful, apprehension of imminent or harmful or distasteful contact on the other. It's not enough to just do those cards. You have to do them early enough so that you can practice them, okay? So you do that, and then you're going to do fine on Part A. Part B, question 1, is mandatory, and you don't know what's coming. I'll give you a hint of a couple of very important topics that might be covered, but you really don't know what's coming. Then I ask you to do 4 of the next 8. So you have choice. 5, 6, 7. I'm really good at math. Okay, 5 or 4 of those 8, right? So you have choice. But if you have to sit there and you think, maybe this one. Let's see how many things do I know. No, maybe this one. Oh, this one will be better. Again, you're going to run out of time. What you can do is actually prepare those ahead of time to a certain degree. I mean, you don't know what's going to be asked or how it's going to be asked. But for example, I could ask, what are 5 sources of law in Canada? All right. So you can actually write those out again on index cards and have them right. Well, actually, you wouldn't even have to do those on index cards. You just do those on a piece of paper, and then you have them handy. And if I ask it slightly differently, well, you can still use your material. Okay, so sources of law in Canada, good Part B exam question. I'll give those kind of hints as I go through, and then you will have a heads up for the exam. All right, back to the sources of law in Canada. There's 8 of them. The first one is judge-made law. You're not paying attention, I give you a slap on the side of the head. That is battery. Okay, there is no Battery Act. Now, there is a provision in the criminal code called assault and battery. We are not concerned with criminal law matters, all right? What we're concerned with is contracts and torts, things that relate to private law. So you've suffered an injury. How do you get compensated? Well, you don't go to the Battery Act because there isn't one. So what you have to do is look at judge-made law and find similar circumstances where somebody had received a similar injury, and then your lawyer would actually go into court and argue that. So there is a whole area of laws that have been developed by judges as opposed to by our legislatures. One of them is contract law. Okay, we have a Sale of Goods Act, which doesn't deal with whether a contract is binding or not. Okay, it deals with the quality of goods and fitness for purpose and things like that. Ways that you can actually have a contract set aside and get your money back. But whether you have a binding element the binding elements of a contract or not, is judge-made law. Okay, so that's one area. Okay, but then the other is something like the Sale of Goods Act. Okay, it talks about merchantable quality. The goods shall be of merchantable quality. What is the legal definition of merchantable quality? Well, then you have to go and find jurisprudence that has interpreted that legislation, and you find out what merchantable quality means. Okay, so that's judge-made law, two respects. In areas where there's no legislation, and then in interpreting legislation. Okay, then there's the legislation itself. Statutes and regulations. Okay, there's two parts there. On the exam, if I said list 5 and you said statutes, you're going to get a half a mark, because a statute says what the law is. Regulations is generally providing the minister responsible for that particular statute to develop procedural law. Okay, so you have the Labor Relations Code of British Columbia, which talks about collective bargaining. You shall do collective bargaining in order to determine, whether you can establish a collective agreement, and you must bargain in good faith. How do you bargain in good faith? It doesn't say so in the statute. So what you do is you go to the regulations. If you do this, you get fined. If you do that, you're not bargaining in good faith. Okay. So there's the Labor Relations Code, and then there's labor regulations. Okay, statutes and regulations. The next one, and I'm not sure I'm doing them in order, I'm trying to remember them, administrative law. If you get sued in court, okay, but what happens if you are charged with an offense by the Competition Bureau, or you are charged with a human rights violation? You do not go to court. Okay, you go before an administrative tribunal. The administrative tribunal is, and as an aside, it says tribunal, and I thought try. Okay, that suggests three people, and every tribunal that I was ever before was like one person, and I thought, well, okay, how do they call it a tribunal? Apparently, it comes from ye old Roman law, when Rome was occupying a certain portion of the United Kingdom. They did not instill Roman law, but they handled disputes, and you had to go before a tribunal, which was a soldier of a certain standing in the Roman army called a tribunal. Okay, so he was like a captain or something. So you'd go before the tribunal and you'd have your court or your hearing. Okay, so that's where that comes from. Anyway, back to the administrative tribunal. They are not judges. They are appointed by the government, because there are so many court cases that they tried to say, okay, let's not overburden our courts. Let's have some of these things decided by a tribunal and resolved without going to court. You go to a tribunal, you don't like the answer, you can generally appeal to court. Okay, I got my coffee. So you have a body of law being built up under the Labor Relations Board, for example. Why don't we call it judge-made law? Well, because they are not judges. This brings in another problem into the equation. If they are not judges, they are not bound by precedent. So they could actually make a decision one way one day and make a decision another way another day. And if you said, well, wait a minute, no, that decision, is the same type of problem. And they'd go, yeah, like tell someone who cares, right? The Employment Standards Branch, the Labor Relations Board follow precedent slavishly for consistency and predictability, because those are absolutely necessary. Human rights, because everything is individual. They have not shown any propensity to look at decisions of the previous tribunals. They have incorporated some judge-made decisions about infringement of our human rights, but generally each individual situation is handled separately. Workers' Compensation Board, they flip-flop. They have. I had a client who went before the Labor Relations, the Workers' Compensation Board, and we had precedent of how they had handled certain situations before. And the Workers' Compensation Board said, yeah, but we've just decided to do it differently. And that was it. They made a decision. They have an appeal procedure. My client said, should we go to the appeal procedure? And I said, sure. The appeal procedure said, well, we're not bound by precedent, so, too bad. And then 11 months later, they went back to the old way of doing things. My client came in to me and he said, well, what about me? And I said, well, okay, there's cracks and you fell through one. The time period to launch a further appeal had expired. My client didn't see that the cost of the appeal would result in any different decision, so he elected not to do it. So unfortunately, there is that particular problem with administrative tribunals. Most of them, however, are building up a body of law which looks like, sounds like, and walks like precedent. The only difference is they're not judges, so they're not bound by it. Okay, the fourth one is orders in council. In the, lecture guide material. The lecture guide material looks like this. I don't think there is actually an order in council in there. No. So what I will do is I will post to eLearn a copy of an order in council just so you can see what it looks like. Basically, this is legislation that is passed when debate in the House of Commons or debate in the legislature isn't required. So for the example I used in BADM 107 is the registrar of the land registry decided that he didn't want to keep hard copies of everything. He wanted to be able to put it onto disks, okay, hard drives. The law said he had to keep a hard copy. So he was bound to keep hard copies of all the documents filed at the Land Title Office. Form A transfers of land, certificates of title, mortgages, easements, right-of-ways, covenants for development of property. All those things had to be, he had to have hard copies. Well, he was filling buildings and buildings and buildings with hard copies. And then, of course, he had to keep duplicates in case that building burned down. And he said, I want to put it on I can put, that whole building's worth of stuff onto one disc, let me do it. But he couldn't because the law said he had to keep a hard copy. So they want to change the law. Like, who cares? The Registrar of Companies cares. Nobody else cares. I don't care whether it's a hard copy or it's on a disc. I need a copy of the Form A. Here you are. Thank you. That's it, right? So, he cared, nobody else cared. We don't want our politicians wasting time introducing a bill, having first reading, second reading, third reading and a vote, having it go to the Governor General, have it proclaimed as law, or, we're still federally, have it go to the Senate, okay, for the same thing. So we want a process whereby those uncontroversial, routine matters can be done. Orders in council. The order in council just says, here's the Attorney General's statement of what has to be done. Here's the presiding member of the Executive Council signing it. This is the provincial one that I'll put online. Presiding member of the Executive Council. Who's that? That's the Premier, okay? Signs it, and then it goes to the Lieutenant Governor of the province. The Lieutenant Governor signs it, and bingo, it becomes law. So for routine things. Okay, so then there's the Quebec Civil Code. Now we're talking about the laws of Canada. 9 provinces and 3 territories, common law. Quebec, civil law for private law matters. Public law, common law. Okay? So it's distinct, and if you have a contract with somebody in Quebec, the outcome of a dispute can be surprisingly different depending upon whether Quebec law is applied, which is a civil code, or whether the BC law is applied, which is common law. So that's another area. Then there is something called municipal bylaws and regulations. We're not going to talk about that. That's business licenses and dog licenses and building permits and things like that. So, but it's an area of the law. Okay, and then there is international law, and there is one other one which I can't remember. So I am just going to consult the textbook. Here we go. Oh, military law. Yeah, no wonder I forgot it. It's irrelevant. Okay. There is a whole separate legal system for the military. There's the military code of conduct, there's military police, there's military prisons, there's military judges, there's military lawyers. So just to make sure that we're being complete, I put that in there. Okay, but we're not interested in it. And then the last one is international law, which we saw first of all on that diagram of public and private law. International law is, it could be incorporated in one of the other sources, for example. The agreement on the USMCA agreement, which replaced NAFTA, is merely a contract. Okay, so it could really fall into one of the other sources of law. For example, if it had to be interpreted, it's done by either judges or administrative tribunals. A treaty is international law, and that's what that agreement is. An agreement between two or more nations is just a treaty, right? And then there's conventions. There's the Convention on the International Sale of Goods, which is a convention passed by the United Nations. Well, that definitely falls into the special category of international matters cross borders. So I separated it out, but in fact you could actually say that this is statutes and regulations, because we signed the convention federally, but before it becomes binding on Canada, there has to be enabling legislation. So the USMCA, for example, there's a federal statute whereby the government of Canada says that's the law of our land. The Convention on the International Sale of Goods, cannot find it federally. It's a provincial matter. It's property and civil rights, and so there has to be provincial legislation, and there is an International Sale of Goods Act passed by the legislature in British Columbia adopting that convention. Okay, so there's that. And then there's also a body of case law, judge-made law. Okay, when there's a dispute and a contract dispute and there's a lawsuit between two businesses, one in Canada and one in another jurisdiction, the judge here will make a decision. That's judge-made law. Okay, but it's judge-made law across borders, so it's quite separate. All right, so those are the 8 sources of law. Some further terminology, standing to sue. It's defined more specifically in the textbook. However, standing to sue is really the capacity to commence a lawsuit. And what it really gets down to is you have to be over the age of 18, you have to be mentally competent, and you have to have a legitimate connected interest, a nexus with the matter. Okay, so my friend Brian Graham sues Robert Cox. And I think, yeah, Brian, good for you. I want to be part of that lawsuit because I think you're right. Well, I cannot be because I don't have standing to sue. Oh, I'm over 18. Yeah, I'm over 18, but I don't have a connection to the matter. It's a contract dispute between those two. I'm a third party to that. Okay, so I don't have standing to sue. Then we have to have what's called a cause of action. Okay. Now, style of cause is the name of a court case. So Regina versus Dudley and Stevens is a style of cause, and that style of cause tells us something about the cause of action. It's public law, probably criminal. Okay. Holden versus Graham, style of cause. What's the cause of action? Well, we'd have to investigate further. It's definitely private law. One individual against another, but we don't know if it's I'm suing him because I was injured in a tort, or I'm suing him for breach of contract or property dispute. Okay, so a cause of action is a legitimately recognized reason to be in court. Okay. Let's see, class proceedings. This is just a class lawsuit, a class action. And we're not going to get into that very much, but it's when a group of people have suffered the same loss and are looking for the same remedy, they can combine into one action, which will allow someone to have access to the courts where they might not have sufficient resources to do it themselves. So I am injured by a new car, and I want to sue the motor car company. Well, motor car companies are big. They've got deep pockets. They will trample me in the lawsuit to the point where I cannot afford to do it. But if there are a large number of people that were injured like I was because of that particular model of car, we can join together, bring a class action. One person sues. If that one person wins, the whole class of people win. If that one person loses, everybody loses. But I would go into my lawyer's office and say, I want to sue the fantastic motor car company. And they would say, oh, they're huge. They've got a big war chest. Give me a retainer of $150,000 and we'll go after them. And I go, whoa, I'm suing over a $40,000 car and I have to give you legal fees of $150,000? And the lawyer will say, well, look, they're going to stomp us like a bug, and we're going to have to, fight this thing, all sorts of motions in court and injunction applications and stuff that, will be frivolous, but which we have to do, and it costs money. Well, if I get together with 300 other people and we all give $10,000, suddenly we've got $300,000 to fight this fantastic motor car company, and they cannot just say, okay, see you in court. They realize that eventually they're going to lose. They're more likely to settle. Okay, and if they don't settle, at least you've got the financial wherewithal to do the lawsuit. Okay, so that's class proceedings. Party and party costs. One of the elements that our legal system has developed in order to stop frivolous lawsuits is party and party costs. So, for example, you call me a stupid, incompetent professor. Well, you do it publicly. You have injured my reputation, so I want to sue you. Everybody that heard you figures, a student failed the exam and he says he's stupid, incompetent teacher because he's blaming the teacher for their own actions. So I could sue you, but nobody really believes it. Hopefully, nobody really believes it. And so we go to court, we go through the whole court proceeding. The judge says, yes, Mr. Holden, you win. Now, what damages have you suffered? And I go, hurt feelings. And the judge will go, okay, nominal damages, because I really haven't suffered any loss. So nominal damages could be something like $1. Okay, so I won, I get $1, and I've just spent $35,000 to $40,000 in legal fees to get my $1. Unless the matter is a matter of principle that's so important to me that I'm willing to spend $40,000, then I won't do it. Okay, and what harm has really been done? However, there are situations when when you do go through the lawsuit and you have spent considerable costs and you win. So I sue someone on $80,000 breach of contract, and I pay my lawyer $35,000. Well, that means 35 from 80 is what? $45,000? It means after I pay my lawyer, I only get $45,000, but I've suffered an $80,000 loss. Well, I won. So I get party and party costs, which means part of my legal fees are paid by the other side. So let's say I've paid $35,000 in legal fees and I win and I get $25,000 for my legal costs paid. Suddenly I've got my $45,000 plus $25,000, which gives me $65,000 plus the 5, which is $70,000. So suddenly I get $70,000 of the 80 I was owed. That helps. Okay, so party and party costs help me if I win. I'm successful. But it also means that the other party pays me the $80,000 and they pay their own lawyer $35,000. So they're now out of pocket not the $80,000 of the dispute, but $105,000, $115,000, whatever. Okay, so the fact that the party and party costs will have to be paid means that the defendant is more likely to say to his lawyer, okay, let's just settle this, all right? Okay. So party and party costs compensate the winning party to stop frivolous lawsuits, but also to provide some compensation for the winning party. Solicitor client costs is I render a bill for $40,000 in legal fees for doing a court case. My client has to pay me that $40,000. Okay, that's solicitor client costs. That's my bill. I do a contract for somebody. It's $2,800. That's a solicitor client cost. They have to pay that bill. Now, if it's a court case and you have to pay me $40,000 and there's party and party costs from the other side of let's say $25,000, that $25,000 comes to me as a lawyer, so I actually only charge you $40,000 less $25,000. Okay, so that's party and party costs. Now, at the bottom of the slide 17, there are terms like solicitor or barrister and solicitor. In Canada, lawyers are allowed to do both litigation and general corporate work, solicitors work. And so we're allowed to call ourselves solicitor and barristers and solicitors. In England, for example, you have to decide whether you're going to be a barrister or whether you're going to be a solicitor. Okay, so when I was practicing, I gave out my practice certificate on December 31st, 2018, as I mentioned. I was a barrister and solicitor. I'm also a lawyer, okay, because everybody that goes through law school is a lawyer. I am legal counsel because I serve as legal counsel for clients. I am also a notary public because all lawyers, at least in the province of British Columbia, become barristers and solicitors and notary publics. In Quebec, notice how I say Quebec. It's because I am part of French, and so I use the French pronunciation rather than Quebec. In Quebec, they have advocates who go to court, and they have notaries who do corporate commercial work and draft contracts and stuff like that. Okay, the one thing I am not is an attorney at law, and I am really screaming into the wind on this because attorney at law is an American term. It's becoming more and more widely used in Canada, which I just hate because it's Americans telling us how we should be saying things, okay? Like we have a roof on our house instead of a roof, okay? And we have a route. We want to go down Route 5 rather than Route 5, okay? Drives me nuts. And the one that I hate the most, I got to tell you this, is he has disrespected me. It is common usage in the United States. He disrespected the flag. There is no such word as disrespected. He showed disrespect for the flag. He was disrespectful to me. He didn't disrespect me, but it drives me nuts. Anyway, attorney at law. My daughter took a grade 12 law course, and the textbook was written by somebody who is not a lawyer, although that person very carefully talked to lawyers to write the textbook and talked to an American lawyer, so he refers to lawyers in Canada as attorneys at law. Anyway, enough said. Let's see, what else is there? Advocate, notary public, attorney at law. Yeah, that's the works. Okay, next screen. It shows the court system in Canada. This is screen 18. The first thing to remember here, and people get trapped by this, is that this is a diagram for all of Canada. Okay, so take off the military courts and Military Court of Appeal. Okay, because we're not going to deal with that. So if this shows up in the exam, that part of the screen, get rid of. Just let me see if pretty sure I have the diagram in my textbook as well. I can't remember what I did. Isn't that amazing? You read a textbook and you can't remember what's in it. Yes, on page 27, I show the court system. This is the one that you should refer to. Okay, if you refer to the one on my screen, and the only reason that I did it that way was because I got it off the internet rather than try to do all those little boxes and lines, but the one in my textbook I did. Okay, so on the one side, there at the bottom is BC Administrative Tribunals. These aren't courts, but because they are part of the system which tries to relieve our courts from so many actions, it's on there. Okay, so if you want to appeal from a BC Administrative Tribunal, it is generally to the BC Supreme Court, although there are some where you appeal to the provincial court, but not usually. Okay, but if it's a contract breach, for example, you cannot start in the BC Administrative Tribunals because there is no tribunal for that. So you have to start, if it's a small matter under $35,000, you might want to start in the BC Provincial Court Civil Division. Okay, if it's over that substantially and there's other elements to the court case, you want to start in the BC Supreme Court. So that makes the BC Provincial Court and the BC Supreme Court as two courts of first instance. Now this is not on my lecture guides, but it is a term that I want you to know. Generally, when I'm lecturing in class, I say that anything I write on the board it's not in my lecture guide are terms that you want to remember. So I'm going to pretend that I'm writing court of first instance on the whiteboard, all right? A court of first instance is where you have to start. So if you start in the BC Provincial Court, they have small claims, they have criminal court, they have young offenders, they have traffic court, and family court. Okay, so we're talking small claims. If you start in BC Small Claims Court, you have one chance to appeal. So the BC Small Claims Court is the court of first instance. The BC Supreme Court becomes the court of appeal. Okay, you cannot go any further just because they don't want small matters like that going higher. Okay, but if it's a substantial amount of money or there are other issues involved, your court of first instance will become the BC Supreme Court. Okay, and this is the diagram I'm talking about. Okay, so you'll find that on page 27. If you have the right to appeal, and it's not automatic as everyone thinks, you apply to appeal to the Supreme Court of Canada. The Supreme Court of Canada is so busy and so overwhelmed that they will decide whether or not to hear your appeal. If they say, no, we're not hearing it, then the BC Court of Appeals decision becomes final and binding. If they say they will hear it, then it goes before either 5, 7, or all 9 judges of the Supreme Court. On the federal side, because we are a confederation of federal government and provincial governments, unlike the United Kingdom, which is a unitary system, right? We have the federal administrative tribunals. This would be the Competition Bureau, the Federal Human Rights Tribunal. Then you appeal to the federal trial court, okay, because they don't have something like small claims, a provincial court. So you appeal to the federal trial court. That ends the matter, all right? But if you wanted to sue for trademark infringement or something related to a corporation governed by the airline or an airline governed by the federal legislation, then you would, start in the federal trial courts. That would be your court of first instance. If you don't like your answer and you have the basis of an appeal, you appeal to the Federal Court of Appeal. If you don't like your decision and you have a basis for appeal, you can appeal to the Supreme Court of Canada. They will decide again whether or not to hear your case. But if you have a tax problem, you're being sued by the CRA, the Canadian Revenue Agency, or you're suing them, you start in tax court. You cannot start in the federal trial court, so tax court becomes a court of first instance. Okay. If you do not like the decision and you have the basis of an appeal, you can appeal to the Federal Court of Appeal. That's your final court. Okay. The Supreme Court of Canada has made it absolutely plain that there are no appeals beyond the Federal Court of Appeal on tax matters. All right, so it looks like we have 4 courts of first instance: the BC Provincial Court, the BC Supreme Court, the Federal Trial Court, and Tax Court. In actual fact, there are 5 courts of first instance, and that is if a government goes to pass legislation and it is challenged by another government as being ultra vires, meaning beyond the powers of that government to do it, then the Supreme Court of Canada becomes a court of first instance in those situations. And the reason is simple. If the federal government decided to pass gun control legislation and they painted it as criminal law, so it falls within the powers of the federal government, the provinces would challenge it because the ownership and registration of guns and licensing falls under civil and property rights under the Constitution, and so it's a provincial matter. Okay, so they're treading on provincial powers. So all the provinces would challenge the federal government. Well, it takes anywhere up to 12 years to get to the Supreme Court of Canada. Okay, so and something this complex would probably take that long. And so what you would have is the federal government legislation passed in the House of Commons. You'd have a gun registry set up. People would be licensed. People would be fined. People would be arrested for illegally having firearms. It would be a mess, right? If suddenly 12 years later, the Supreme Court of Canada said, well, no, that's ultra vires the power of the federal government. That legislation is null and void. Let's cancel it. Well, what do you do with the gun registry? What do you do with all the people you put in jail? What about people who are been fined? Okay, so they cannot have that. So the matter gets referred directly to the Supreme Court of Canada. So the provinces start an action against the federal government, and it can be vice versa, by the way. They go right to the Supreme Court of Canada for a declaratory judgment. Okay, declaratory judgment. Okay, that's one of those terms you should remember, because what that means is that before the legislation is even passed and valid, they want a declaration of whether it's ultra vires or not. Okay, declaratory judgment. So 5 courts of first instance, that has been in the past a Part B exam question. Okay, there are all sorts of problems with our court system. Okay, not problems so much with the results, but problems with the cost and the time and the stress. Okay, so is there a better way? I think that there is, and a lot of other lawyers think so, and our system is set up to accommodate it, and that's alternate dispute resolution. When I first started, well, let's put it this way. For the last 10 or 12 years of my legal practice, I never once drafted a contract that did not have a arbitration clause and then later on a mediation and arbitration clause to settle disputes and stay out of the courts. Okay? Because it just struck me that there was no good reason to say, okay, let's take this matter to court, let's not go to arbitration, because it's so costly, it's so time consuming. It takes 2 to 3 years to get into the BC Supreme Court. Okay? I'm not talking about an appeal from small claims court, I mean starting an action. So you're suing someone for $80,000 for breach of contract. You'll be lucky if you're in court 3 years later. Justice delayed is justice denied. Witnesses disappear, witnesses' memory lapses, evidence and exhibits disappear, all sorts of problems. I have right now a client, a former client, who is being sued in small claims court. It's a frivolous claim. It's a stupid claim. But he has to defend, right? Well, the person that's suing him had two witnesses. One of them dies, and the other leaves the country and goes back to Europe where he was from. Now this person has to go in and try to convince the judge that, hey, a letter that they wrote to me, I should be able to use as evidence, which is hearsay, right? So it's a real problem. And so those things happen in real life. My client wants to bring in a witness, and it's someone that used to work for my client, and they're not exactly friends, but then they parted on good terms. Well, I told my former client that he should get legal advice, but one of the things he should do is give a subpoena to his former employee to have him show up. Because if you do not do that and you get into court and you ask him to be a witness and he doesn't show up, the judge doesn't say, oh, well, let's just adjourn this until another day when you can get this person to come in. The judge says, hey, we're all here, proceed. But if you subpoena them, then they have to show up. So if they don't show up for some reason because they got up, oh, wow, what a beautiful day, I think I'll go golfing. And then at 4 o'clock they go, wait a minute, I was supposed to be in court today. Well, if you have a subpoena, then you just say to the judge, I subpoenaed this person, and then they issue a bench warrant for them, okay? And then you get to adjourn. But, if you don't do those kinds of things, it's, and it's already been over a year and a half since the lawsuit started. Things get delayed because of what? COVID-19, Anyway, so there's a better way. Less stress, less costly, and faster. Alternate dispute resolution or arbitration, mediation and arbitration. When I started teaching this years ago, there were 5 or 6, well, no, I think there was 5 advantages listed in textbooks and things. Over the years, because I was involved in doing this and teaching about it, I have expanded that list so that there are 10 advantages, okay? And to be fair, you should never make a presentation and outline the advantages of something and ignore the disadvantages. That is unethical. So I have also included the disadvantages. I will say right up front now that there are 10 advantages and there are 5 disadvantages, and the disadvantages are, how can I say, mostly irrelevant. So there are tremendous advantages to using alternate dispute resolution. I sort of shot myself in the foot in a way, because there have been, later in my legal career, 2 times when clients had legal problems, and instead of going to court, they were going to go to mediation and arbitration, and they were going to mediation, and I said, look, I don't have to be there. I mean, if you don't like what's happening, just say no and walk away. Okay, so there's no downside in mediation, because you don't get trapped. You might decide to settle. That's fine. You can do that at any time, but you don't have to settle. Okay, and so they went to mediation, and both times it was resolved, and both times I didn't get to do the arbitration or go to court. So sort of shot myself in the foot. But I found over the years I'd rather have a happy client than a client that pays me a lot of money and then is unhappy. Because what happens is you lose the client, okay, because they think you're a bad lawyer. So anyway, downsides. We're going to go through the advantages and disadvantages of arbitration fairly quickly, because this is review. You can look in the textbook. They're outlined very clearly. Okay, advantage, faster. You get into arbitration in 3 to 4 months instead of 3 years. Less costly. It's not to say that it's inexpensive. So if you say cheap on the exam, you lose money, okay? Because it's not cheap. Nothing is cheap, okay? Cheap means poor quality. It's just less expensive than going to court. you're looking at about $11,000 instead of $35,000. Okay, so let's just grab this and okay, this is covered on pages 36 to 41. Okay, confidentiality. Everything in the court is open to the public. Okay, so if you have a special pricing structure that gives you an advantage over your competition and you get sued with somebody and the judge says, tell me your special structure, and you have to tell the judge it's in the file, your competitor can come down, pay $5. Might have gone up by now, but pay $5 and see the file. You go to arbitration, you can specify confidentiality and everything will be kept separately. Preserving ongoing relations. I had a client who got into a dispute and wanted to sue the other side. I said, we cannot. We put in an arbitration clause. You can take them to arbitration if you want. But what you should probably do is go to mediation. And they went to mediation, and they both decided that it just didn't make any sense that either one party's insurance company would pay or the other party's insurance company would pay, so they settled the matter. Arbitrators will view the scene. Judges do not say, okay, let's just leave court, let's go down to where the accident occurred so I can have a look. They don't do that. You have to bring in exhibits and pictures and argue it in court. I used to bring in Patrick Williams, who was the president of the BC International Commercial Arbitration Center, as a guest speaker. He's now retired, so we can't do that anymore. But he was involved in an arbitration where scaffolding beside a building fell down and somehow caused an accident out in the roadway, which is quite a ways away. And the judge said, okay, the scaffolding falls down. How did it cause an accident out in the road? And the lawyers that were doing the arbitration looked at each other and went, we don't know. So the arbitrator said, well, let's go. And they all piled in the car and they drove out. Okay, there's the building, there's the scaffolding, there's a hill. Scaffolding collapses, rolls down the hill, onto the road, accident. All right, everybody understood. Back they go and they resolve the matter. Judges don't do that. Flexible and longer hours. I can talk about this one. I had a court case one time and went down to the courthouse at 9 o'clock, and we go in and we talk to the registrars, who then says, are you all ready to go and everything? And yeah. And then we find out what court we go to, and then we go to it. We came in one day, and the registrar said, oh, I'm sorry, the judge is sick. You don't have a judge. So then you have to go to file scheduling, another registry, and stand in line. I got there, and there were a whole bunch of lawyers standing around. They're all arguing with the registrar because a number of judges were unavailable that day. So the clerk said, the clerk said, well, okay, who has a matter that's really serious? And I was standing in the back, and I said, I do. And everybody turned and looked at me, and the registrar said, what? And I said, well, my court case involves a mentally incompetent person that is going to be put in a home, and the family members are arguing over which home it should go to, and so the judge said, okay, you have Judge so-and-so in courtroom such and such. The other lawyers looked at me with knives in their eyes. But I was doing the best job for my client, okay? And it was a matter of some urgency, not quite that urgent though. But anyway, I got my judge. Wow, whoopee. Well, court starts at 10 o'clock. So we went up to that courtroom at 10 o'clock. We sat there 10:10, 10:15, 10:20, 10:25, 10:30, 10:35, going on 10:40, and the judge comes in. Why is she late? Because she wasn't planning on hearing a case that morning. She had to, pardon me, she had to read the file, get up to speed before she came into court. So we start at 10:40. At noon, you adjourn for lunch. So the judge can go off and have a nice couple of martinis and meet with some of her friends. Or no, she goes back to her office and she tries to write the judgments on other matters that she heard that she was supposed to be doing that day before she was asked to fill in for the judge who was sick. So we break at 12 and we come back at 2 o'clock. At 4 o'clock, we're still going. Judge says we adjourn for the day. So I have had, what's that, 2 hours in the afternoon, 1 hour and 20 minutes in the morning. So I've had 3 hours and 20 minutes of court time in an 8-hour day through no fault of my client, all right? But we had to come back the next day. I don't, so all that other time from 9 o'clock on, I don't charge my client. Yes, I do. If I'm there with my client, I'm not working for other clients, so I have to charge my client. Now for the 2-hour break over lunch, I could do other things, except I was meeting with my client over lunch and talking about what happened early in the morning and how to take care of some things in the afternoon. So it's very expensive with a client. Go to arbitration. The arbitrator will contact you and say, okay, we'll start tomorrow at 7 o'clock. No, let's make it 7:30, North Vancouver, where both of you live. I'll get a room at the Holiday Inn Hotel. See you there. You walk in, there's coffee, there's muffins. You start at 7:30. You're working until 12 at noon. The judge says, okay, I think we have to have lunch. And you get up and you go, okay, and you're going to go and, have a nice lunch somewhere. No, you're not. He'll order in coffee, or she'll order in coffee and sandwiches, and you keep working through. Gets on to 5 o'clock. 5 o'clock, court's over at 4, but you're still there at 5, and the arbitrator will say to you, how are we doing? And I go, well, I'm finished. And the other fellow says, well, I got about another half hour. Okay, let's keep going, and you do it. So the arbitrator is going to get through a lot quicker than a judge, more flexible and longer hours. Decisions are final and binding. That's the whole idea of arbitration. You go to court, 3 years, you get into Supreme Court, you have your court hearing and everything, and then you have to wait 60 days to find out if the other side is going to appeal. If they appeal, it's going to be another year or so before you get into the Court of Appeal. Okay, so arbitration, you have one shot. You win, you lose, you lose. That's it. Okay, there are limited rights of appeal. But it's really only where there is a patentable error at law. Okay, error in the facts, too bad, you had your chance. Error at law, if the arbitrator said, well, yes, there is a breach of contract, but I'm not going to enforce it. There's a valid contract, but I'm not going to enforce it. Well, that would be an error at law. Okay, so then you get to appeal. But you have to go in on a hearing and tell the judge, this is why I want to appeal. And they are not going to just say, okay, sure. They're going to be very hard on you. The whole point of arbitration is you're not supposed to be in court. Okay? So that's the decisions are final and binding. So the sword of Damocles is not dangling over your head. And if you don't know what that refers to, then look it up on the internet. Okay. Enforceable as judgments. Going to arbitration would be totally useless if you got an arbitral award, but there was no way to enforce it. Okay, when you go to court after you get your judgment, the judge doesn't reach into the defendant's pocket, pull out some money, and give it to you. You have to then go and enforce your judgment. You can garnish the defendant. You can bring them in on payment hearings. You can seize and sell assets. You can register your judgment against land. All sorts of things you can do. Well, if you got an arbitral award and you couldn't do that, it would be useless. So what you can do is take your arbitral award down to court, pay a fee, they stamp it, and now you've got a judgment that you can enforce. Better still, and here's the one that relates specifically to international law. If I sue someone, if I have a contract with somebody in Mexico to sell them milk, for example, and I send the milk and they don't pay me, I can sue them. Do I sue here in BC or do I sue there in Jalisco? Well, if I sue here in BC, then I've got to go down there and register my judgment, and then I have another hearing to find out if I can register it or not. But if I sue there, that's hugely expensive. I shouldn't say hugely. That's slang. It's incredibly expensive because I have to go down to Mexico, I have to hire Mexico counsel, and I have to fight the court case under civil law, which I don't know anything about, rather than common law. Okay, so that's a real problem. So going to court has that other stumbling block. But if I go to arbitration and I get my arbitral award, it's enforceable internationally in about 133 countries in the world, maybe even more. I haven't checked lately. But back in 1958, the courts, the United Nations passed two conventions, one on the international enforcement of judicial awards. So a judge makes an award in Canada. The idea was that you could take that award to Germany and enforce it, or you could take it to Mexico and enforce it, or you could take it to Japan and enforce it. Only 6 countries, a lot of countries signed that convention, but only 6 of them did the required legislation to make it law in their country. So there is no international enforcement of judgments except by what we call comity, which means we'll recognize yours if you recognize ours, and that doesn't happen very often. But that convention was signed in 1958. At exactly the same time, the United Nations also passed a convention which said that arbitral awards from one country can be enforced as a judgment in another country. Everybody signs it. Everybody does enabling legislation because what was the big deal? Hardly anybody was doing arbitration. The courts didn't care because if a BC court has to recognize a judgment from Brazil, they're giving up some of their sovereignty, some of their inherent jurisdiction. But they didn't see it that way for arbitration. So arbitral awards are enforceable in most parts of the world. Okay, so those are all the advantages. Now we're going to get into the disadvantages, but just before we do that, we're going to take a break because it is already 2 o'clock where I am, and I have not had lunch. So I'm going to go have lunch, and then I'll come back and finish arbitration. Let's see. Okay, I'm back after lunch. Now the sound of my stomach growling won't interrupt with the lecture. We were at slide 21, I believe. Yes, the disadvantages of arbitration. This is covered in pages 40 to 39, 40, and 41 of the textbook. No body of precedent is the first one. Because arbitrations are confidential, one arbitral award cannot act as precedent in a subsequent arbitral award. This, I don't think, it is sort of a disadvantage, but it's not a tremendous disadvantage. And the reason is that just because we have arbitrations taking place doesn't mean that the courts are no longer doing anything. The courts have thousands and thousands of cases on any number of topics, okay? And so there's still a body of precedent that can be used in arbitrations, just not arbitral decisions, okay? And the other thing is, of course, if you have judicial decisions of Supreme Court justices or Court of Appeal judges or Supreme Court of Canada, they carry a lot more weight than arbitral award decisions anyway. So it is a disadvantage, but not a very serious one, I don't think. The limited right of appeal is both an advantage and a disadvantage in the sense that it's an advantage. Your court case is finished, or not court case, your arbitration is finished. Just get on with your life, okay? But the disadvantage is that if you lose and you think you really should have won, you may be precluded from an appeal, and probably will be precluded from an appeal. So that is a disadvantage. Okay, so that's one that we should consider. The third one is I don't really think is a disadvantage. I invited a Court of Appeal justice to be a speaker for my small business classes at Capellan University, and he came out and he was very good, and we asked him questions about arbitration. And I specifically asked him about the disadvantages, and one of the ones that he raised was that when you go through an arbitration, you don't feel like you've had your day in court. And I almost laughed because I thought he was kidding, okay? Because I haven't done a lot of litigation, but I have done, some, and I can never remember walking out of court listening to the losing side say, "Gosh, golly darn, I lost, but I feel so darn good that I had my day in court." And so I just, but he's a Court of Appeal Justice, and I'm a professor at a university, so I have to put it in there because he saw it as a disadvantage. I don't think it is. You're never happy to lose in court or in an arbitration. Okay, so that's one of them. Now the other one that is listed in a number of articles and everything is that there is no equitable remedies. Well, that's not quite true. Our arbitration acts in the province of British Columbia say that arbitrators are not entitled to provide equitable remedies. Now, what's that mean? Well, there's damages and injunctions, okay, as remedies, for a breach contract, for example. Those are inherent remedies that a court has. The courts also have the inherent jurisdiction to provide equitable remedies, such as specific performance. If I want to buy a piece of property, and we enter into a contract for the purchase and sale, and I give you the deposit, and then you give me the deposit back and say, "No, I'm sorry, I don't want to sell." Well, pardon me, we have a contract. I have given the deposit. Whether I've given the deposit or not is irrelevant, but we have a contract. You can't just back out of it because you don't want to do it anymore. So the question then becomes, will damages suffice? No two pieces of property are alike. And so I wanted that particular piece of real property because that land was what I wanted. It faced the south, it had a view of the water, it's, for any number of reasons. So to say, oh, well, he has to buy something else and he's not going to get quite what he wants, so I'll give him some money too, would not be a just remedy. In those situations, the courts can say, "Defendant, I am specifically ordering that you perform the contract," specific performance. So the defendant has to give me the property, okay, and then I have to pay for it, all right? So that's an equitable remedy. Arbitration statutes say they can give damages and injunctions. Well, actually, they only say damages. Injunctions is another equitable remedy. So damages isn't sufficient, right? In a lot of cases. And this statute says that arbiters are not judges, so they do not have inherent jurisdiction to give equitable remedies. If it just stopped there, then it would be a tremendous disadvantage. But it doesn't stop there. It says, unless specifically provided for in the arbitration contract. So it could only be a disadvantage if a business person goes on to the website for the BC International Arbitration Center or any other arbitration center. They give you sample clauses, okay? And you think, oh, there's a clause. Why do I have to hire a lawyer? I'll just use this clause. And then you find out you want specific performance or you want an injunction and you are not allowed to grant them. Okay, that would be a problem. But if you do your risk management and say, all right, I need an arbitration clause, I should pay a lawyer to draft it, then the lawyer will put in a clause that says the arbiter shall have jurisdiction to provide equitable awards, and then that disadvantage is eliminated. The fifth one is public policy considerations. And this may or may not be a problem. For example, if the arbitral award is looking at a restrictive covenant, Okay, now the first thing about a restrictive covenant is, and we'll get into this later as a review, you should remember this, but I'm not at all sure that you will. A restrictive covenant is a clause in a contract where you're buying a business and the vendor says, yes, I want this amount of money, and you say, okay, if I pay you that amount of money, I do not want you to be able to compete against me for a certain period of time. Well, that restricts competition, and therefore the court's prima facie position is that it's void. Okay. Now that is a rebuttable presumption, because what you can do is you can come back and you can say to the judge, well, I would never pay this person what his business is worth if he could turn around the next day and use that money to compete against me. Okay. So it's advantageous to me to pay that money and get that covenant. It's also advantageous to the vendor because there's no way he would get the value of his business unless he provides that. So between the parties, there's a good reason for that clause. Then there's this public policy consideration. So that's the first step. It's prima facie void. Can you rebut the presumption? Yes. Is there a public policy reason why this should not be allowed? That's the third thing the courts look at. And then if they say there's no public policy concerns, then they go on to look at the clause and decide whether it's valid as to time, area, and nature of business covered. So there's this public policy thing in there, which arbiters, I don't even know whether they could consider it or not. It's not an equitable remedy, but it's some reason why it should not go forward. So this could be a real problem in arbitrations if they come up. But I don't see very often that there would be public policy considerations that would be involved in a lot of arbitrations. To give you an idea of a public policy consideration, this is not a contract matter, and this is not an arbitration, but there was an aircraft, a passenger plane that went down off the coast of Newfoundland, and the military was sent out, as was private ships, to search for survivors. Well, they're not really searching for survivors. What they're doing is trying to pick up the bodies, because nobody's going to crash in the Atlantic in an aircraft liner and survive hypothermia if you make it into the water. Anyway, one of the military vessels that got there, the military personnel were put in boats and sent out in little rafts or little boats to pull the bodies out of the water. One of the sailors, whose job was not rescuing, suffered trauma, and he sued the military and the Canadian government because he suffered this mental trauma. Well, the court said there's a public policy reason why this case has to be dismissed. I mean, you cannot have everybody in the military suing the Canadian government because they suffered trauma from going to war or having to do a rescue, when really that's one of the things that goes with the job. So there's a public policy reason why that case was dismissed. Not that he didn't suffer, but that he could not recover. Okay, so that's the kind of public policy thing that they're talking about. Does not crop up very often. So if it is a disadvantage, it's a very insignificant one. Okay, so at the bottom of that page, note, this is a risk management consideration. If you want to have mediation and arbitration, it has to be in the contract. Why? Well, let's say you and I are involved in a contract, and I breach it. I know I've breached it. I just don't want to pay you. So you say, okay, Peter, I'm going to sue you, and I'm going to have to give my lawyer $35,000 as a retainer to start, and I'll see you in court. Oh, wait a minute. Okay, why don't you and I go to arbitration? Why would I go to arbitration with you? It's faster, it's less costly, and all those other advantages. For you, not for me. I say, I'm not going to arbitration. You go write out that $35 retainer to your lawyer, and I'll see you in court. Well, you might not have the $35,000 to do that. Okay? So it's very unlikely that I would agree that if you're suing me, well, let's do arbitration because it's better. It drags on for 3 years, who cares? Your witnesses get lost or lose their memories. Exhibits go missing, all the better for me. So it has to be in the contract. Okay. To conclude this, and this is new material that you would not have in BADM 107, whether you had the course with me or with Chris Hardcastle, Mike Molson, or Shafiq Blue. And that is, there may be, there are definitely ethical considerations in arbitration, and there is now potential legal considerations. The ethical consideration is, I'm a business in BC, and you are in Australia. You want to sell my product. So you come to me and you say, I want to be your distributor. And I say, okay, you can be my distributor, but if we have a dispute, it's resolved by way of arbitration in Vancouver at the BC International Arbitration Center. And you go, hey, but wait. I have to come all the way to Vancouver. I have to bring all my witnesses all the way to Vancouver. I have to bring the exhibits all the way to Vancouver. That's unfair. Well, it might be unethical, but if I'm in the driver's seat, if you need my product and I don't need you, then I could insist on that. It may be unethical, but it is not illegal. Okay, so there's this ethical concern. Then we have a twist from the Heller versus Uber Technologies Inc. case, which happened just in, I think, 2018 in Ontario. Uber, New York company, Uber driver in Ontario has a dispute. The contract between the two of them says that it has to go to arbitration. Well, Uber's big, driver, independent, small operator, not much money. Obviously, to go to New York to fight the arbitration would have been very difficult for the Uber driver in Ontario. But Uber didn't do that. They said, hey, if there's a dispute between you and I, it's going to go to arbitration in the Netherlands under Dutch law. What's our contract got to do between two civil or common law jurisdictions with the civil law jurisdiction in Europe? Absolutely nothing. Why did they do it? You're an Uber driver in Ontario. You may be willing to drive to New York to do the arbitration. Are you going to fly to Europe, stay in a hotel, hire counsel in Netherlands that knows civil law and fight the arbitration? So Uber put that in there because that way no one would ever be able to bring a dispute against them. Well, not no one, but pretty much no one, right? Well, anyway, the person went to court in Ontario, and Uber goes in and says, hey, there's an arbitration clause. The court case has to be stayed. This has to go to arbitration. It made it to the Court of Appeal, and the Court of Appeal looked at it and said, two problems. One is he's more like an employee than an independent contractor. So the Employment Standards Act of Ontario applies. The Employment Standards Act in Ontario says you cannot contract out from under it. You have to go to the Employment Standards Branch. If you don't like the decision, you get to appeal to court. You do not go to arbitration. Okay? So it was contrary to a statute. You cannot contract out from under some statutes. So on that basis, it was illegal. And then the judge, to close the door completely, said it's also, besides being illegal as contravening a statute law, it's also illegal under common law, judge-made law, because that contract is unconscionable. Unconscionability is one of the reasons why a valid contract can be set aside, or a provision in a contract can be determined to be void. So the Court of Appeal said, arbitration clause, void. He gets to go to the Employment Standards Branch. So that was the first time in any jurisdiction where an arbitration clause did not result in a stay. Well, I shouldn't say the first time that it didn't result in a stay, but it didn't result in the stay, and the first time it was ever held to be illegal. Okay, so that's Ontario. What about BC? Well, judge-made law. The Employment Standards Act in Ontario cannot be followed or applied in BC because it's a law of that jurisdiction only. We have our own, it's different, okay? But the common law decision of the judge that this was contrary to the rule against unconscionability is a common law judge-made decision from a similar jurisdiction that can be followed by BC law. So we do have this now potential problem with illegality that's applicable in BC and other common law jurisdictions, even those in the States. Okay, all right. So just to conclude, we have a number of statutes that come into play as far as arbitration goes. The first is that we have the Arbitration Act in BC. It used to be called the Commercial Arbitration Act, and it dealt with breaches of contract. BC said, no, we want more and more things to go to arbitration, so they took out the aspect that said it only applies to commercial arbitrations, and they changed the name to Arbitration Act, which means it can hear arbitrations with respect to family law matters, property law matters, commercial law matters, tortious matters, okay? That was the first thing. So, what's that mean? Well, from our perspective, it means that a BC business that wants to settle a dispute with another BC business puts in an arbitration clause. It will go to arbitration pursuant to the Arbitration Act. If a BC business, though, has a dispute with a company in Germany or a company in Japan or a company in India, then they go under the International Commercial Arbitration Act. Which one's that? Well, that's the one that deals with cross-border conflicts, okay? But it is the International Commercial Arbitration Act. You cannot have a family law matter heard in the International Arbitration Court. Why? Because family law is pursuant to a statute in BC and it's pursuant to statutes elsewhere. Well, that's conflicting laws. But contract law, international, okay? All right. Then the third one is if I have a business in BC and a business that enters into a contract with a business in Mexico, and they want the dispute solved by arbitration, they really have two potential avenues. They can go under the International Commercial Arbitration Act because BC is one country and Mexico is the other. They also have an avenue to resolve their disputes under the United States-Mexico-Canada Agreement. Article 2022 of NAFTA, which is now incorporated in this new agreement, says that they have this commercial arbitration center to resolve private law disputes. Okay, NAFTA and now the USMCA are designed to resolve disputes between the three nations. Well, pardon me, my allergies are kicking in. The negotiators of NAFTA decided when they were doing some amendments to it years ago that maybe they should try to expand the applicability of NAFTA to allow for the resolution of private law disputes as well as public law disputes. So they put in Article 2022, which then created arbitration centers in Mexico, the United States, Canada, which would resolve private law disputes. Because if I have a contract dispute with somebody in Mexico, I couldn't go to the government and say, hey, under NAFTA, let's go after this guy. It was public law. This is a private law matter. Now they have this system. It's called the Commercial Arbitration and Mediation Center of the Americas, CAMCA, okay, Where are the CAMCA centers? Well, there's obviously one in Mexico, and it's Mexico City. There's obviously one in the United States, and it was called the Arbitration Center in New York. Why? Because it was there for hundreds of years, 100 and some odd years, okay? Then in Canada, you would sort of expect, well, okay, Toronto or Ottawa, but no, it's in Vancouver. Why? Because we had a commercial arbitration center in Vancouver that was well known internationally long before the other provinces, okay? So the center in Vancouver is designated under CAMCA. There's also a fourth center, and that's, of course, in Quebec City, because Quebec said we are a nation too, we want our own center. And they insisted that there be one there. It's totally inactive as far as I know, because there's hardly any commerce between the United States and Quebec. Okay, so that concludes Chapter 1. Chapter 2, just a heads up, it's on tort law. I did a tort video years ago which covers all the torts. And unfortunately, it was for the previous textbook, and so I think it refers to chapters 4 and 5, but they are the same as chapter 2 in my textbook, and that I don't want to do the video again. And so I'm just going to use that. So it's going to talk about chapters 4 and 5, which just means chapter 2. The torts are the same because they haven't changed. The explanations are the same because they haven't changed. And it refers to, hello, BADM 107 students, section 76, because it was a mixed mode section that I was doing it for. This course is being taught in North Vancouver and the Sunshine Coast campus, and I had to be in one week and one in the other. Well, when I was teaching torts in Sunshine Coast, I couldn't be teaching it in North Vancouver, so I did a video. So you watch that video. Now, two things. In that video, we don't go into damages very much, okay? So what you want to do is you want to refer to, I'll just tell you what pages those are on, because I expanded it considerably in my textbook. All right, here we go. Damages are covered on pages 87 and 88. There are special damages, general damages, punitive and exemplary, aggravated, and nominal damages. You should have a general understanding of the differences. Injunctions are covered, and the concept of mitigation is covered. So read those out of the textbook. Mitigation just means if I'm injured by your negligence and I do not do anything to mitigate my loss, which means lessen my loss, I may not recover anything. Okay, it's a requirement at law that you do this, and they will investigate it in court. The suit that my client has, that I was talking about earlier, former client has, somebody is suing him because they think they suffered contractual damages. And after starting the lawsuit, they went, good, well, I'm going to get a whole bunch of money when I win the lawsuit. And so they just left Canada and they went back to their home country, and they came over to file a few more articles for court, and then they went back to the home country because that's where his wife is. Well, he did nothing to try to find a job to lessen the loss that he suffered. And so in court, even if he manages to prove that he was wrongfully dismissed, which I think is an erroneous one, but I'm not practicing law anymore, so even if he was to win that, he might not recover anything because he did not do anything to mitigate his loss. Okay, so that concludes chapter 1, and it also concludes at least everything else that I wanted to say about, pardon me, no, I said two things, didn't I? The other thing is, if we just dash down to Okay, here we go. Oh darn, I can't find it quickly. There are a number of defenses to tortious actions, and I want you to specifically know those defenses. Okay, the damages are covered on slide number 31, and then there are defenses to torts, and they are again in the textbook. There's 6 of them. Well, obviously, the damages in tort could be a 5-mark question. The defenses to tortious action, there's 6 of them, so that could be a 5-mark question. And you'll recognize them because, for example, volenti non fit injuria, he who accepts the risk shall bear the loss, is a defense. If I know the dangers and I accept them and I get injured, I cannot sue you. Waivers of liability are contractual defenses to a tort. The Negligence Act is when there's 2 people that cause you an injury, they're both negligent. Well, the Negligence Act doesn't say that they were or weren't negligent. What it does is it says, okay, we'll split the cost of compensating you between the 2. There's extirpi causa non oritur actio, which means I cannot go after you if I've committed a wrong. Okay. And there's some others too, but I just wanted to give you a heads up that I want you to know that as well. All right, so and I'll put in a slide outlining those. I don't see that there's one there right now, but I'll put it in right now. So it'll be posted to eLearn and you'll be able to follow along. Okay, that's everything on this video, and I can't imagine you'll enjoy watching it, but the nice thing about it is that if you have any problems with it, you can rewind it and listen to it again. You can read the textbook, and if you still have problems, then you just contact me and say, Professor Holden, what did you mean by that? Okay, and that is lecture number 1 out of the way.